Hello, everyone, and welcome to the Wills, Women, and Wealth podcast, where we lead you holistically from overwhelmed to empowered through estate planning. I'm Elsa W. Smith, your Maryland estate planning and probate attorney, and the host of the Wills, Women, and Wealth podcast. This podcast is for women who value their health, their wealth, and the legacies that they are creating. Each episode is going to bring you interviews in the areas of finance, law, mental and physical health, and more. I'll also share educational episodes that answer your questions on wills, estate planning, and probate topics. We welcome your feedback. So let us know if you like the show. This and all future episodes will be available on YouTube, Spotify, Google Podcasts, and Apple Podcasts. Speaking of Apple, please leave us a 5-star review on Apple. Your review helps us get seen by more people and get the message out. If you're watching this on YouTube at Elsa W. Smith Law, hit the subscribe button so that you don't miss any of our upcoming episodes and you join our growing YouTube community. Now, on with the podcast. Today's topic is 4 estate planning horror stories and how to avoid them. Today I wanted to share a few scenarios dealing with poor or no planning at all. Unexpected and outdated estate planning documents. We're also going to touch on a personal representative who just wasn't a good fit for the job, as well as an unmarried mom's nightmare when her partner died. So let's get right to it. Our first scenario is scenario 1, and that's of John and Jane. The first scenario, as I said, let's deals with a woman, so we're going to call her Jane, and the partner she's with is John for this scenario. They were close friends for many years. John had never married, and he had no children. John was diagnosed with a rapidly debilitating illness, and he eventually passed away. He died. Before he died, John told Jane that it was his wish for her to have the home. Now, unfortunately, John died before recording a new deed to reflect his intent, because when he died, the deed to the home was only in his name. So an estate had to be opened in the probate court to deal with John's home, among other matters. So for context, this took place in the District of Columbia. Now, how could this horror story have been avoided? Well, John could have signed a transfer on death deed, naming Jane as the beneficiary. Now, with a properly executed transfer on death deed, John's home could have avoided probate, and his wish to have Jane keep the home would have been fulfilled, right? So it's important to note that while transfer on death deeds are available in the District of Columbia, they are not valid in the state of Maryland. That's why it's so important to consult with an estate planning attorney, a license in your jurisdiction, to provide you with accurate information tailored to your specific situation. Now, what's another estate planning tool that could have been used here? Well, depending on several factors, such as John's financial situation, the size of his estate, and whether he prioritized keeping matters private and out of public record, John could have placed his home in a trust, and he would be what's called the grantor trustee, the one who initially funds the trust. So the trust would have now become the owner of the home, and John would be the primary or grantor trustee, as I mentioned. Now, assuming that Jane was the person that John believed was suitable for this role. He could have named Jane as successor or a backup trustee. So at John's death, Jane would have become the trustee without need for court intervention. John could have left instructions that Jane would be allowed to remain in the home for as long as she wanted to. Depending on Jane's financial situation, it might have been to her benefit from a tax perspective, for the trust to be the owner of the home instead of her. If it was John's intent for Jane to remain in the home, this is yet another way that the desired result could have been achieved. So now let's look at scenario number 2. Scenario number 2 involves Mr. Beasley. Now, Mr. Beasley was an 80-year-old man in poor health. Mr. Beasley had 4 sons with his first wife, who eventually died. After her death in 2010, Mr. Beasley created a will, leaving his entire estate to his 4 sons in equal shares. In 2012, that's 2 years later, Mr. Beasley remarried to wife number 2, and let's call her Barbara. Barbara is 75 years old. Mr. Beasley wanted to create a revocable living trust as he had multiple properties that he wanted to move or transfer into that trust. One of those properties, one of the 4, was the residence that he shared with Barbara. He also wanted to get a new will drafted to include his new wife. Unfortunately, the day after his consultation, Mr. Beasley died of congestive heart failure. Needless to say, neither the trust nor a will were drafted. So the only document indicating Mr. Beasley's wishes was the 2010 will, which did not include Barbara. All right, so for context, this is in the state of Maryland. So how could this horror story have been avoided? As I said many times, a new marriage is a triggering event that is caused to update your estate planning documents. Illness can strike any of us at any time, right? So in this case, Mr. Beasley was known to be in poor health. He knew that, his family knew that. So Mr. Beasley should have updated his estate planning, first of all, as soon as he realized that he got a serious diagnosis. But secondly, when he married Barbara in 2012, right, he could have included Barbara in his will and indicated what portion of his estate was to go to her. He also could have done this with a trust. So, what other options are available in this scenario? Well, Mr. Beasley could have added Barbara to the deed of their primary residence while they were married. Now, as a married couple, the new deed would show the residence as owned by tenants by the entirety, right? Meaning that Barbara would have owned 100% of the residence. At a minimum, the residents would not have needed to go through the probate process, and Barbara would not have had to worry about a place to live at the age of 75 or so. I should note that in this particular scenario, Barbara has rights under Maryland's elective share law that she would have to exercise in order to benefit from Mr. Beasley's estate. Now, as this show is about how to avoid estate planning horror stories, a discussion about the Maryland's elective share law goes beyond the scope of what we're going to talk about today, but I would be remiss if I didn't at least mention Maryland's elective share law and bring it to your attention. Now let's go on to scenario number 3, the story of Miss Jackson. Without an estate plan, and in this case, without a will naming who you want to be your personal representative, you don't get to choose who the best person is for the role. Instead, a court appoints someone for you in the case when the case is in probate. Right. So sometimes that choice may not be the person you would have wanted. Right. So Miss Jackson was elderly and physically challenged, but she was still sharp, very sharp mentally. She had wanted to get her estate plan done ever since she became a widow a few years ago. She didn't have any estate planning documents in place. Now, Miss Jackson had 3 children, each with their own set of personal challenges, none of whom she considered responsible enough to manage her estate. She had considered a very dear friend of hers to serve as personal representative of her estate. That was a person she considered responsible and had the right temperament to deal with her surviving adult children. Unfortunately, Miss Jackson died suddenly and left no will. She died intestate, and you all have heard me mention that term before. That means dying without a will. So, for context, Miss Jackson lived in the state of Maryland. The estate would have to be probated and governed by Maryland's laws of intestacy. Now, as I've said, if you don't have an estate plan, Maryland's got one for you, right? So in this case, since Miss Jackson was a widow and she had her adult children, her estate would be divided equally among them. Now, in order to administer an estate, you need a personal representative. Now, one may petition the court to do so. Now, in this case, one of Mrs. Jackson's children, Francine, petitioned the court to be personal representative. Given that Francine was Mrs. Jackson's daughter, she had preference over Mrs. Jackson's trusted friend, assuming that the friend would have petitioned the court also. Right. So fast forward, Francine gets appointed as personal representative. Right. Being a personal representative requires you to be very organized and pay attention to court deadlines. Francine didn't fit the bill in either sense. She was too distracted with drama in her own personal life, and she didn't maintain good records. And as a result, she missed filing deadlines and often had to resubmit documents that were incomplete when they were initially filed. So the probate process dragged on much longer than needed, frustrating Francine's other siblings who wanted their payout as soon as possible. The delays increased the cost to the estate and decreased the amount that would eventually go to each of the surviving children, right? So, in short, Francine was not the woman for the job. She is not who Mrs. Jackson would have wanted for the role. Now, what's one way that this scenario, this horror story, could have been avoided? Well, if Miss Jackson would have had her will in place before she became seriously ill, the will would have named her trusted friend as the personal representative. The friend could have then been appointed by the court, given that Mrs. Jackson's wishes were clearly stated in her will. Her estate would have been probated in a timely fashion and in a manner that honored Mrs. Jackson's memory. As I've said many times, the time to create your estate plan is not when you're in crisis. You have an opportunity to put the right people in place and the people who have the right skill sets all have a part to play in your estate plan, but the time to do it is when you are of sound mind and you are in relatively good health. And if you are struggling with this process right now, reach out to a licensed estate planning attorney in your jurisdiction to help you work through those hurdles, those speed bumps. And now, lastly, let's take a look at the fourth scenario, and that involves Kayla, Brian, and Ebony. Okay, Kayla and Brian had been in a serious relationship for many years. While they did not marry, they did have one child together, Ebony. One day, Brian, who was a 40 something year old male with no known health issues, had a heart attack at work and died. Brian did not have a will or any other estate planning documents. Now, Kayla assumed that Brian's family would consent to her being the personal representative of Brian's estate, especially since Ebony was his child and would be the sole heir, right? Kayla would have to seek consent of the court because of his surviving parents would would have preference as personal representatives if they petitioned the court to do so. Now, the estate in this case would be distributed according to Maryland's laws of intestacy. Why? Again, because Brian died without a will. In this case, as mentioned, Ebony is Brian's sole heir. However, since Ebony's a minor, estate proceeds going to her would need to be placed in a trust for her benefit. As mentioned, no trust planning for Ebony was done before Brian died, so no estate planning whatsoever. Kayla had a cordial relationship with Brian's family. Her family adored Ebony. Brian did not have any siblings, but both of his parents, so Ebony's grandparents, were still alive. Now, after Brian's death, according to Kayla, Brian's family became really hostile towards her. Brian's mom petitioned the court to be the personal representative and tried to shut Kayla out as much as possible. The home that Kayla, Ebony, and Brian shared was in Brian's name only. After the funeral, some of Brian's family members, including Brian's mom, came to the home and started taking some of Brian's personal items from the home. Now, due to several conflicts between Kayla and Brian's family, Brian's estate is now in litigation in the probate court. And Kayla does not believe that Brian's family is honoring his memory by the manner in which they are treating her and the stress that it is causing to Ebony. Now, how could this last story, this horror story, could have been avoided? Well, at a minimum, Brian should have created a will naming Kayla as his personal representative if that was his intent, right? Ebony's birth presented another opportunity for Brian to create or update his estate plan. For Ebony, Brian could have created a testamentary trust. That's a trust that's in the will itself, and it is created after his death. And as I said, it is part of the will. Or he could have created a revocable living trust for Ebony's benefit. The choice of one tool or another depends on what Brian's personal and financial goals and circumstances were while he was alive. These are issues that an estate planning attorney could have assisted Brian, Kayla with. He could have or she could have helped them work those issues out. As for Kayla, if Brian wanted to pass ownership of the home to her, he could have retitled the home and added her to the deed. Now, in this case, they weren't married. Remember that. The deed would have to specify that they were joint tenants with right of survivorship. So at Brian's death, Kayla would have been 100% owner of that residence. So unmarried couples do have certain challenges when it comes to estate planning, but there are tools that can allow planning for the inevitable and tools that will protect those that you leave behind. Okay. Now, I hope that these horror stories and what you can do to avoid them have helped you in some way. Remember, what I've shared is not to be considered legal advice, but just for informational purposes only, right? We help clients in Maryland and the District of Columbia craft estate planning plans that are tailored to their specific situation. We do that every day. And I know many of you who are watching have probably put off your estate planning for a while now. I invite you to book a 15-minute free call with a member of our team. There is absolutely no obligation, and we are here to help. As I said, I hope these scenarios have been helpful to you. Please feel free to share this episode with those that you know and could benefit from it. I am Elsa W. Smith, your Maryland estate planning and probate attorney. Thank you for watching this episode of the Wills, Women, and Wealth podcast. I'll see you in the next video. Take care.